Yes, good evening to everybody. Welcome to the class of the law of charts. And I was dealing the second unit where I completed the general defenses and the liability of the state. And now the joint tort liability is concerned. Now read what I posted on the screen. Anyone can unmute and read.
What is
What
joint
is
liability?
joint liability?
Joint liability denotes the obligation of two or more partners to pay back a debt or be responsible for satisfying a liability. A joint liability allows parties to share the risk associated with taking on debt and to protect themselves in the event of lawsuits. An individual subject to joint liability may be referred to as joint liable.
Yes, the
Jointly
joint
liable.
liability. Yeah, please. Yes, Professor Dr. Mohammed Saheb Hussain. Yes, joint liability denotes the obligation of the two or more partners. The partners may be the parties, or like a principal agent, or like that fiduciary relationship, like a father and son, and a priest and disciple, to pay back a debt or be responsible for the satisfying the liability. A joint liability allows the parties to share the risk associated with the taking on a debt and to protect themselves in the event of the lawsuits. An individual subject to joint liability may be prepared to as a joint liable. So the liability will be shared depending upon the negligence part they have taken in it. So that is called joint liable and severally liable. In the both the way they could be liable. Either jointly or severally they can make it out both. So later on it will be decided, because a person cannot get the benefit for the one cause of action two times the damages. So that would be the thing. So let me see the definition of the joint tortfeasors. The tort means civil wrong. Feaser means doer. Tortfeasor means tort.
Wrongdoer.
Wrong.
Wrongdoer.
Tort doer. Feaser means doer. Tort means civil wrong. Civil wrong doer means tortfeasor. So when a tort is committed with the several persons, all the persons involved in it becomes the joint tortfeasors. Sir, I did not participate in it. Just I am sitting near the gate to see if any person is coming or not. Is it not the joint liability?
Yes, sir. It is joint liability.
They will be have the common intention, though they are not involved in the act, but it's the watching the people standing in front of the gate. If any passerby is going on or they are not, so he will also equally liable like the person who is actually taking action in the tort. So in addition to this, all persons will be responsible for the same tort and will be deemed to be a joint wrongdoers in the eye of law. Joint wrongdoers are known as
Joint tortfeasors.
joint tortfeasors. That's my point. Now at this point, it becomes important for one is to understand, in order to establish a wrong committed by the joint tortfeasors, there must be some connection between the act of the alleged tortfeasor to that of the other. Can a passerby be a joint tortfeasor?
No, sir.
Answer no. Unless until he have some part in it, and unless until he knows some connection with the offense which is committed over there. So Sergeant L.J. words regarding the can be quoted as follows. I quote, there must be a concurrence in the act or acts causing damage, and not merely a coincidence of separate acts which may the conjoined effect to cause damage. So that was the actually the thing. And quote. So there must be a concurrence. Concurrence means, in the judgment, the one judge will write the whole judgment. The second judge, what he do know? I concur with my learned brothers.
Means
Did you see
agree, sir.
judgment?
Yes, sir.
Did you read any judgment?
No, sir. We didn't read.
Yes, please. In the AR, in any, you read the judgment. A person will write the judgment. The some other person he can show the view, or the second judge say, I concurred with my learned brother, the learned person so and so. Means I agree with him. There must be a concurrence. Means there would be some cause should be there in the act or acts causing damage, and not merely a coincidence Like a coincidence means Darinavoya Danaya, a pedestrian. Are you following me?
Yes, sir.
Yes, sir. Darinavoya Danaya endukanaala vandi, Darinavoya Ramaya endukannaddu?
దారిలా అంటే దా వస్తుంది కాబట్టి మళ్ళీ దానే రైమింగ్ అవుతుంది సార్.
యతి ప్రాస.
ఎస్ సార్, యతి ప్రాస.
అది చెప్పాలా మీరు? సార్ మీరు తెలుగు పండితా సార్? తెలుగులో నాకు 64 మార్కులు వచ్చినాయి ఇప్పుడు 10th క్లాస్లో, ద హైయెస్ట్. So now let us come to the point, and not merely a coincidence of separate acts which by their conjoined effect means together effect and cause damage. So how do you read it? I quote, there must be a concurrence in the act or acts causing damage, not merely a coincidence of the separate acts which by their conjoined effect cause damage. I unquote. That is the style of writing, the quotation. Did you get my point? Say yes.
Yes, sir.
Good. In Palghat Coimbatore Transport Company versus Narayana, there was a collision. Collision ante endi sir? Collusion ante entidi? I will give the explanation to you with a graphic. There was a collision between the two buses which resulted in the death of one of the passengers. Further, the suit filed by the representative of the deceased under the Fatal Accident Act, it was held that the owner of both the buses companies would be liable because they jointly together did harm and a passenger was died. So deceased representative filed a case under the Fatal Accident Act. At that instance, they're jointly liable and severally liable. Suppose the one bus fault is 50%, then other bus is 50%, then 50-50 will be paid. Suppose one bus fault is 175%, another bus fault is 25%, then only 1/4 will be paid by the 25% and 1/3 will be paid by the
75%.
75%. I would like to know whether you are following my accent, whether you are following my example or not. I would like to touch it. Now let us see what is the difference between the collusion and collision. So here graphically that I made it. Collusion means joined hand together for a certain cause. What is collusion? Read anyone?
Collusion means an agreement, formal or informal, among. Sorry, sir. Collision means an arrangement among or on behalf of enterprises in the same line of business, which is designed to limit competition among them.
You did not read it within parentheses.
Douglas Greer,
You
1992.
did not read within the parentheses. Here you did not read. This is where I am highlighting.
Formal or
Collusion
informal,
means
sir.
an arrangement
Yes,
within
sir.
parentheses, formal or informal, among or on behalf of enterprises in the same line of business, which is designed to limit the competition among them. So that is called the collusion. A successful collusion occurs when firms in an industry behave in such a way that, given the relevant supply and demand functions, including those rivals, the combined profit of the entire set of the firms is maximized within parentheses George Stigler 1961. That is the collusion between the two persons. And the collision means accident. See, here is a head-on collision. You see the picture, graphic.
Yes, sir.
Yes,
It's
sir.
a head-on collision between the
Cars.
two
cars.
Yes, two vehicles. So then that is called collusion. That is the difference between the collision and the collusion. Okay.
Okay, sir.
Sir.
Yes. Now let us come to the, with regard to a joint tortfeasors, the following three prepositions can be taken into consideration. Prepositions another than actually emanala. There is a mistake. It is there. What do you call it? Three prepositions another. You know what is the prepositions?
In, under, below, those are prepositions.
Emanala ikkada actually the word is proposition. Means statement. Proposition means statement. See, I will give the example to you here. See, a preposition is a word or a group of words used before a noun or a pronoun or a noun phrase to show direction, time, place, location, spatial relationship, or to introduce the object. Some of the example of the prepositions, the words like in, at, on, off, and, to. Prepositions English are highly idiomatic. The dangerous thing in the grammar is pass on చెప్పండి తెలియకపోతే preposition. Okay, now the proposition means a statement or assertion that expresses a judgment or opinion. A proposition is a declarative sentence that is either true or false, but not both. For instance, the following are the propositions. Paris in France, true or false?
True, sir. False, sir. Don't know, sir.
What is the tower in the France?
Eiffel Towers.
I appreciate your general knowledge. Okay, London is in a Denmark.
No, sir. It is in United Kingdom.
Okay, I appreciate. Utrecht in which country?
Pass on, sir.
Amsterdam.
Pass on, sir. Sir, Spain, sir. Madrid.
No.
Amsterdam
is the capital of Netherlands.
Netherlands, I suggest.
And Utrecht is the fourth biggest city in the Netherlands. Okay, the reference has come, that's why I'm saying. So now here you should not say preposition, you should say
Propositions.
propositions means statement. Number one, circumstance and which the joint liability arises. Number one, agency. Yes, if agent didn't edit particular thing, then joint liability falls on
Principal.
principal and agent, like vicarious liability. I told you the relationship between the principal and agent, partner and other partners, master and servants. Is it not?
Yes, sir.
Yes. So agency, the concept of the agency provides us whenever one person implies, this is a grammatical mistake. It is not a one person like this. One hyphen person, he implies, if they are wrong, it should be like this, implies. What is that? Comes right is implies, that is the way. EMPLOYS implies, because it is a third person singular and the verb should be either a singular or plural. The verb should be singular or plural, that is the idea behind it. So one should have to write in that manner. So one person implies or authorizes or procures, because all S is there, authorizes, procures. Why? If you know it, you tell me. If you don't know it, say pass on.
Pass on, sir.
When the third person singular is there, subject, then verb should be a third person singular. That is called subject agreement. One person is a third person singular. Hence, the verb should be yes or yes should be added. Implies, he, she, it, works. They say one person implies, one person authorizes, or one person procures. All S should be added. Yes or yes added to the verb. So that is the subject agreement rule. I are antava andi? I are going antava?
No, sir.
Endukana
I
I
have gone.
R is a plural
I am the
form.
single, sir.
And I is a
Yes, sir.
first person singular form.
First
So the
person
verb
Yes, sir.
should be
am.
verb should be singular form. Singular form is
Sorry.
am. Plural form is
Are.
are. That is, sorry, the grammar class, sorry, the laugh tarts class. It's a combination
Laugh
of
tarts.
everything. A person when he speaks, a person when he writes, he should write like a lion and lioness. Adol antar sir, andar lion antan ga sir, mari appudu anandi sir lioness kuda. Okay, lion and lioness. General class academic study. If you say the male, it includes the female also. So one person implies, so that is the reason eventually procures another person commit a tort. Law takes into account the wrong, both of them, and eventually both are participated, and agent became a jointly and individually responsible for the action of the agent. Even though the principal is not present over there, but no fault of the principal would be held liable because of relationship as a principal and agent. So then you will see the Arnold versus Patterson case law. In the aforementioned case, two dogs at a concert was belonging to two different owners. Two dogs. Dog is a feminine gender or a masculine gender? Yes,
Masculine genders.
it is a masculine gender. What is the feminine gender?
Pass on, sir.
Bitch. B-I-T-C-H. Okay. సరదాన వేమన్నా ఇంటికాడ మాట్లాడి నాకు వినబడుతున్నాయి. మ్యూట్ చేయి. Yeah, feminine gender is called B-I-T-C-H, bitch అంటారు దాన్ని. Masculine gender ఏమో dog అంటారు. So which a different owners attacked the flock of sheep. Sheep అంటారు. ఈ గ్రూప్ ఆఫ్ షీప్ ఎందుకన్నారండి? ఫ్లాక్ అన్నారు చెప్పచ్చు, ఆర్ హర్డ్ ఆఫ్ షీప్ కూడా అనొచ్చు. ఆర్ యూ ఫాలోయింగ్ మీ?
Yes, sir.
మళ్ళీ ఏ గ్రూప్ ఆఫ్ కీస్ ఏమంటారండి? బంచ్ ఆఫ్ కీస్ అంటారు, బంచ్ ఆఫ్ గ్రేప్స్ అంటారు, ఫ్లాక్స్ ఆఫ్ షీప్ అంటారు, హర్డ్ ఆఫ్ షీప్ అంటారు. సో దీస్ ఆర్ ద different for the number of the groups. We will call in the different style. Include many of them. Okay, మాట్లాడతాను ఇన్నది మాట్లాడతాను. I can see them. Please mute. When you want to give the answer, you can unmute it. Otherwise, your personal talk will be heard by me. When a suit was brought against the owner of the dogs, one of them put forth a claim that he would be liable only for the half. When he says only liable for the half, means the rest of the half borne by that other person. But it is finally held that both the owners will be held liable for the whole damage. Can a person get the total damage from one person and the total damage from the another person? Answer is
No, sir.
Answer is no. The reason is no one can enrich himself or herself at the cost of others. Repeat. Sir, ఇంకొకసారి చెప్పండి సార్. No one can enrich himself or herself at the cost of the others. So same cause of action, you cannot enjoy the two remedies. Only one remedy, either 50-50 or 1/4, 1/3, or vice versa. So vicarious liability, we know, I need not to explain vicarious liability. Because a person will not be, what is the vicarious liability based on the two maxims? What are those maxims? Anyone? Respondent superior. Pratibha, you are
QE facet per LEM facet per se.
slow. That is why your voice, no? Respondent superior. It is coming.
Sir, next one, QE facet per LEM facet per se.
Yes, these are the two maxims based on it. The vicarious liability is sad. Q facet per se, Q facet per se, per alien per se. So that is the two maxims based on that. Now let us see the accessory liability. In the context of the English common law, liability for the participating in another start is considered in the form of joint liability, but at the same time, it is ambiguous whether procurement is a concept which is a different from that common design, but is a subset of it. Considering it the whole, it can be concluded that the few law favors the procurement as a subject of law rather than taking it as a form of common design. So what is the procurement reason? Suppose అరే కత్తెదర విని నరుకుతాను అనుకో, పక్కడు కత్తిచ్చింది అనుకోని ఏమవుతుందండి? ఈజ్ ఆల్సో ఈక్వల్లీ లయబుల్ ఆర్ నాట్?
Yes, sir.
Yes, sir.
మళ్ళీ ఇక వాడిని ఒక టెక్నికల్ వర్డ్ అంటారు ఎవడు కత్తిచ్చినోనికి. ఏంటి ఆ టెక్నికల్ వర్డ్ చెప్పండి లాలో? అబెటర్. He abates means he encourages. Are you following me?
Yes, sir.
What is the spelling of abater? A-B-E. A-B-E.
Pure.
A-B-E.
Pure.
Say the rest of the spelling.
ABETOR.
No. ABETTOR. What is the spelling?
ABETTOR.
ABE. Let us check it whether I am right or not, because always checking is very much. See, did you see it now?
ABETTOR.
Did you see it now?
Yes, sir.
Yes.
sir.
Yes, a person who encourages or assists someone to do something wrong, in particular to commit a crime, she pleaded guilty to manslaughter as an aider and abettor. ABETTOR. Sir, ఈ గోట్స్ని కానీ మనం షీప్స్ని కానీ ఆర్ కౌస్ ఆర్ బుల్ ఆక్స్ని సాక్రిఫైస్ చేస్తాం చూడండి సార్, దాన్ని అనాలా సార్ మళ్ళీ? For the sake of exporting it to the other countries, the flesh, the meat. Do you know that the word? If you know it, you tell me. If you don't know it, say pass on.
Pass on, sir.
Did you understand the question?
Yes, sir.
Where the sheep or goats or cows or buffaloes or anything will be slaughtered for the skin as well as the export of the meat to the other countries. Abattoir antaru danni. Emantaru?
Abattoir.
Abattoir. Spelling ABETTOIR. Abattoir. చూడండి ఇప్పుడు. ఓ ఈ లేదు, ఏ ఉన్నది, సారీ ఈ లేదు, అబట్టాయర్. Abattoir. Did you see the how abattoir they are keeping hanging in the cold storage? Abattoir, that is. What does that mean? It is a place where the slaughterhouse. So abattoir ku abattoir ki దగ్గరనే ఉంది సంబంధం. So looks alike. Don't be confused. Okay? Say yes. Say yes.
Yes, sir.
Very good. I appreciate. So now the question comes, access are also equally liable jointly or severally. Is it clear? Say yes.
Yes, sir.
మీరు ఎస్ అన్నంత వరకు నేను ముందుగా పోలేనండి, నేను, దట్ ఈస్ మై వీక్నెస్.
Okay, sir.
ఓకే. CBS songs. What is CBS in abbreviation? What is
Central Bureau of India.
abbreviations? What is CBS in abbreviation? Why you are keeping quiet? I told you the 4 types of the abbreviations. FBI, CBI, initialism, ICRISAT, NATO, SATO, acronym.
Acronym, sir.
Then IMP, important. LLB, L full stop, B full stop, that is called shortening. I can't,
sir.
you can't, I do. That is a contraction. Where the first we are there. Now I ask, what is CBS in abbreviation? Everybody is keeping quiet.
Columbia Broadcasting System.
BBC, CNN. These are all initialism. So CBS Songs Limited. Limited is the right way of writing. Is the right way of writing? Answer.
Capital L, small t, D.
There should be a. After D, there
Capital
should
L.
be a. After D, there should be a.
Full stop.
Full stop, period. After small v, there should be a. There should be a. Full stop. Oh, no. Okay. So CBS, the CBS should be always italics. The CBS Songs Limited versus Amstrad Consumer Electronics PLC. What is this PLC? What is this PLC? మీకు ఆయుధం ఇచ్చాను కదండి, పాస్ ఆన్ ఆయన ఆయుధం ఇచ్చాను కదా మీకు.
Pass on, sir.
Why you are taking, sir, మేము చెక్ చేస్తాను sir. You cannot check it in the short time. Where PLC means full form programmable logic controller. PLCs are used in the various applications in industries such as the steel industry, automobile industry, chemical industry, energy sector. The scope of the PLCs dramatically increases based on the development of all the various technologies where it is applied. There we can say PLC. Is it clear?
Yes, sir.
What is the full form of PLC?
Programmable logic controller.
ఛాలెంజ్ చేస్తా మీ దోస్తులను అడగండి వాట్ ఈస్ ద పిఎల్సి అని చెప్తే చెవు కోసుకుంటా నేను ఏం కోసుకుంటా ఎస్ చెవు చెప్పాలా ఇయర్ ఓకే నౌ ద పిఎల్సి షుడ్ నాట్ సపోజ్ టు రైట్ ఇన్ దిస్ మేనర్ ఇట్ షుడ్ బి రిటర్న్ దిస్ ఈస్ ద వే ఆఫ్ రైటింగ్ క్లియర్ ఎప్పుడైనా సరే కేసులా either it ends with the full stop if nothing is there. Suppose if it is continuing, it ends with the
Comma.
Full stop.
comma. Where by it was held that the procure is a joint tortfeasor only if he shares the design of the primary tortfeasor. It is primary tortfeasor, co-tortfeasor, or assistant tortfeasor. It doesn't matter because he is equally liable. Is it clear?
Yes, sir.
Yes, I appreciate.
Yes, sir.
Part of the common design. In case of read.
Fish and Fish Limited versus Sea Shepherd UK.
Yes. What is the wrong there here?
Pass on, sir. Sir,
Generally,
D after
we
D.
don't write
After
sign.
After D.
After, there
We
is no
don't
dot.
write sign here in the case law. We try to avoid it. We write only and. This is the style of writing. Are you following me? We don't
Yes, sir.
write any sign in the case law.
Okay,
We
sir.
write the equivalent
Spelling.
and. The sign is called.
Pass on,
The
sir.
sign is called. The sign is called. చెప్పరాదండి సార్
Pass on, sir.
చెప్పరాదండి Give me the answer.
Pass on, sir.
Ampersand. 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 Fish and Fish Limited. Limited తర్వాత full stop should come over there. V తర్వాత full stop should come over there. సార్ మీరు full stopలు కామాలు అన్ని everything I can make the correction. See Shepherd UK. UK is
United Kingdom.
What is UK?
United Kingdom, sir.
నీ దండం పెడతా 4 టైపులు ఉన్నాయి చెప్పిన నేను ఈయన అబ్రివేషన్ యూకే ఏమవుతుందని నాకు తెలుసు ఫుల్ ఫామ్ యూకే ఏమవుతుంది ఈయన
Initialism,
అబ్రివేషన్
sir.
ఎస్ ఇనిషియలిజం అని చెప్పాలా వాట్ యు సే ఇనిషియలిజం
Initialism.
చెప్తాను టుమారో ఐఎమ్ గోయింగ్ టు డీల్ ద ఇంటర్ప్రిటేషన్ ఆఫ్ స్టాట్యూట్స్ ఫర్ ద ఐ పుట్ ఇట్ దేర్ టు హోమ్ కోనేరు లక్ష్మయ్య ఎడ్యుకేషన్ ఫౌండేషన్ ఎక్కడ ఉన్నదండి
Pass on, sir.
Vijayawada, deemed university. I'm going to a lecture over there for the students as a resource person. There also I may mention, ఏమని అడిగాడు రామయ్య ఇల్లు ఎక్కడ అని అడిగాడు ఏమని అడిగాడు రిపీట్
రామయ్య ఇల్లు ఎక్కడ
అయ్యో ఆయనకేం పోయిందండి ఆయన కొడుకులున్నారు మనవడాలు ఉన్నారు అండ్ సో మెనీ ఆయన ఎందుకు ఎక్కాలా కప్పు కలవడానికి కప్పు అంటే తెలుసు కదా రూఫ్
ఓహో ఆ కప్ప సార్
Okay,
టీ
okay.
కప్ అనుకుంటా
ఏది థాచెడ్ రూఫ్ ఆయన అన్నది రామయ్య ఇల్లు ఎక్కడ అంటే వేర్ ఈస్ ద హౌస్ ఆఫ్ రామయ్య బట్ వాట్ హీ పర్సీవ్డ్ రామయ్య ఇల్లు ఎక్కడ అంటే ఇల్లు మీద పైకి ఎక్కడ ఎందుకు కప్పదానికి
Okay, sir.
ఎవరు
ఇప్పుడు అర్థమైంది, sir.
ఏమంటాడు ఆయన పోయే కాలం ఏందండి ఆయన 80 సంవత్సరాలు ఉన్నారు కొడుకులు ఉన్నాడు మనవడు ఉన్నారు అందరు ఎక్కుతారండి కప్పు ఎక్కుతారు ఆయన ఎందుకు ఎక్కాలా అంటారు వీడు అడిగింది ఏంటి అడ్రస్ ఆఫ్ ది రామయ్య అంటే అర్థం ఇంటర్ప్రిటేషన్ ఏమైతుంది
Wrong అయితే.
I say something, you receive something. a statute says something, the parliamentary say in one view that then the other view will be given by the advocates, judges, and the lawyers, including the court. But court always think it. What is the purpose of it? అనేది ఆలోచించి చెప్తుంది కోర్ట్. కాబట్టి court decision is right. Okay? Adi,
Yes, sir.
you listen it, how I teach to them. Interpretation of the statutes. See, Shefford, UK, it was taken into account that in order to establish the accessory liability on the person, two elements are necessary to be proved. What are the two elements? One, the defendant acted in a particular way. This was the reason which led to the occurrence of the tort by the main actor. ఇక్కడ మెయిన్ యాక్టర్ ఒకటి ఉంటాడు, గెస్ట్ యాక్టర్ ఒకటి ఉంటాడు, సపోర్టింగ్ యాక్టర్ ఒకటి ఉంటాడు, సైడ్ యాక్టర్ ఒకటి ఉంటుంది. ఆల్ విల్ బి హెల్డ్ లయబుల్. ఇస్ ఇట్ క్లియర్? Is it clear? Main actor liable, side actor liable, guest actor liable jointly and severally. Two main actors would have further done so pursuance of joint plan or common design. There is no establishment test for the determining the common liability. It varies from one case to another case depending upon the facts and circumstances of the case. Sir, నేను ఏం చేయలేదు సార్. ఏం ఇచ్చినవరు సార్? ఓన్లీ నేను నిచ్చెనిచ్చిన సార్ అంతే. దేనికి ఇచ్చినవరా? గోడ ఎక్కదానికి. ఓకే, నిచ్చెన ఎవరు పట్టుకున్నాడు రా? ఇంకోడు పట్టుకున్నాడు. గోడ దిగి ఏం చేసిండ్రా? వాడు దొంగలు ఇచ్చిండ్రు. జాయింట్ లయబిలిటీ అవుతుందా లేదా? ఎస్.
Yes, sir.
The person who has given the ladder, the person who holds the ladder, the person who climbs the ladder, jointly and severally liable for the offense. Is it clear?
Yes, sir.
Say yes. Okay. The nature of the tortfeasor liability, they will be jointly liable over there naturally. So let us see the nature of the liability. The joint tortfeasor is always in the advantage of the plaintiff or the injured party, lays down the numerous provisions by way of the which justice can be served to the plaintiff. It is always at the discretion of the injured party. Injured party can make it out, or the plaintiff to either sue one of the many joint tortfeasors for the whole damage caused to him, or to make all the tortfeasors liable for all the damages incurred by them. So now the person who is injured will have the discretion to include the name of the people, those who involved in that offense. So somebody has burnt a farmer's haystack. Some people looking at it and they are laughing by looking at the haystack burning. To be strictly speaking, they are the passerbys. When they are passerbys, they should generally pass it or try to help the people to extinguish the fire. But they are laughing. So the owner saw it. They included their names also because he knows the names of the person, those who are laughing when his haystack is burning. The owner has given the complaint that these persons only who are the tortfeasors. It is the persons. They have to prove that, sir, we are only the passerbys. When you are passerbys, why you are standing there and laughing at when the haystack is burning? If you are having any human touch, you have tried to extinguish the
Fire.
Their joint liability would be there unless until they prove it they did not involve in such an act. అందుకోసమే ఏం చేయాలండి? ఒకవేళ ఉంటే హెల్ప్ దెమ్, ఇఫ్ నాట్ ట్రై టు ఎస్కేప్ ఫ్రమ్ దెమ్. అచ్చా, ఉరికిందనుకోండి మళ్ళీ కుక్కలు ఎమ్మడ పడతాయి, మళ్ళీ అది కూడా జాగ్రత్త చూడండి. ఆర్ యు ఫాలోయింగ్ మీ? సే yes.
Yes, sir.
సో బీ కేర్ఫుల్. కట్టెలు కొట్టేకాడా, పెళ్ళాన్ని కొట్టేకాడా దూరం ఉండాలా, పోవద్దు. అదర్వైజ్ in your house there is a inferno, there is a third world war. Okay, say yes.
Yes, sir.
Yes, read, anyone unmute and read this illustration.
If there are two defendants A and B, and in an aforesaid suit against them, defendant A is found to be at 60% fault and defendant B is found to be at 40% fault. Now, if C is the plaintiff in this case, C has the discretion to either collect the entire amount from A or B, or to collect the amount in regard to each person's liability.
Yes. See, in the incident, there are two defendants, A and B, in an aforesaid suit against them. Defendant A is the found fault with the 60%, and B is having the fault with the 40%. Now the C who has got the injured, he is the plaintiff, and C has the discretion either to collect the entire 100% from A, or collect entire 100% from B, or he can take from A 60%, from B 40%, regard to the each person's liability. Suppose if A pays the 100% to C, but A can have a right to claim the reimbursement from B, how much? 40%. Because A paid
60%.
100%. When A paid 100%, he can claim from B. He can claim from B how much? How much? How much?
40%.
40%. Sir, simple mathematics kadandi idi. When A has paid the 100% to the C, but his fault is only 60%, then he can realize the 40% from
B.
B. Is it a difficult task, difficult question which I asked you? Is it a difficult question?
No, sir.
But why
Sir.
you are keeping quiet? Anyone,
Don't know, sir.
whoever comes first, he can join, take it part. So we have that law reforms, Married Women's and Tortfeasors Act 1935 also comes. Various other acts have come over there. Then the joint liability and several liability will be applicable now. One of the loopholes involved in the case of joint tortfeasor is that it can make a defendant end up paying the damages which are disproportionate to his liability in a suit. Such instances come to the light in the case of the insured and uninsured defendant. If any one of the defendant in the suit has to deeper pocket or a larger insurance policy, then he may be under an obligation to pay most of the damages even when he was not a primary defendant. I already given an example. It's a total fault of the 100% fault of the cyclist. And is a cyclist collided with a stationary automobile. Stationary car. Spelling stationary spelling. Stationary spelling.
CATIONARY.
NARY చెప్పాలా, not ERY. Good, I appreciate. So 100% fault of the cyclist. The stationary vehicle was there. The people, those who saw, some of them did not see. Generally, what is the opinion of the other people? They say, please, the poor cyclist, please pay him something. Why? Because why? Because అని చెప్పద్దు మళ్ళీ. Why? Because అని చెప్పింది అనుకోండి, Professor Hussain, students never say why because. Either you say why or you say because. ఎందుకంటే అది ఎట్లుంటుందంటే, 7 సముద్రాలు దాటిన తరువాత మాయల ఫకీరు ప్రాణం చిలకలో ఉన్నది. అరే 7 సముద్రాలు ఏంట్రా, సప్త అంటేనే 7. అర్థమైందా అండి బాలనాగమ్మ? వై బికాజ్ అని చెప్పద్దు. వై బికాజ్ అన్నారు అనుకోండి, అరే ఎర్రగడ్డ నుండి వచ్చిండ్రా వీడు. ఎక్కడికి వెళ్ళి వచ్చిండు?
రెడ్డిగడ్డ
హాస్పిటల్ నుండి. వై అన్న చెప్పండి, బికాజ్ అన్న చెప్పండి. ఎందుకంటే ద రీజన్ ఈస్ A motorist having a deep wallet, deep
Yes, sir. Small wallet.
pocket, even though he did not do the wrong. So deep pocket theory generally available, mostly either the fault of anybody. First and foremost, insurance company should have to come to the rescue of the victim. Is it clear?
Yes, sir.
Yes,
Yes.
sir.
Contribution between the joint tortfeasors. Walla percentage batti, the contribution should be there. Suppose if you don't wear the helmet, how much the contribution for the negligence? 20%.
20%.
If you don't tie the seat belt, 20%.
20%.
If you drunk and driving, met with an accident, 100%.
100%.
Are you following me?
Yes, sir.
Yes. Here one maxim is there. Exturpi causa non aritor actio. Read. Read.
Extirpe causa non aritor actio.
Actio. The meaning is
Actio.
no action arises from an illegal cause. No action arises from an illegal cause. If the two A and B, they colluded each other and they robbed the bank and they say 50-50% we will share it. Can they go to the court for the 50-50% agreement?
No, sir.
Why? Robbing itself is a illegal act.
Illegal act.
So no action arises from an illegal
Illegal
cause.
cause.
Exturpi causa non aritor actio. So English case law, Everett versus William, where the plaintiff and the defendant were the partners in a highway robbing, and by the way of the collected that 2,000 pounds, and then when the plaintiff filed a suit for the share of the sum, the court dismissed the suit on the ground of being a scandalous and impertinent act, because the act is exturbi causa non aritor actio. So one famous case law is there, Merriweather versus Nixon. This is a landmark case law where it was laid down that in common law, a wrongdoer cannot maintain an action for the contribution against another wrongdoer, even when the one seeking the contribution would have satisfied the full claim of the damages, and the rule was popularly known as Merriweather versus Nixon rule. The facts of the case involved the following. M and N conjointly destroyed the machinery which belonged to R. R having the machinery, M and N both conjointly destroyed the machinery belonging to R. Eventually, R brought an action against the both of the obtained a claim of 840 pounds by way of the judgment delivered in the his favor. In whose favor? R favor. What is destroyed? Machine is destroyed. Who destroyed? M and N destroyed. Those who the whole amount was levied on M, the whole amount was paid by the M, and who again sought contribution from N for the half of the amount by filing a suit against him, the count laid down by the M would not recover. So, Merry versus Nixon, whether it is a right case law, the rule of Merry versus Nixon existed and the applicability, but existed with several exceptions to it. These exceptions will be discussed in detail in the forthcoming segment of the article. But naturally, exceptions are there. Suppose two bus drivers, they collided with a passenger and the passenger died. The one bus owner paid the entire amount, but he is having a right to claim from the other tortfeasor the rest of the amount. Otherwise, the other person who is a joint tortfeasor, he will be scot-free. Are you following me?
Yes, sir.
So, exception to the rule in Merriweather versus Nixon with regard to the contribution between the wrongdoers, the application of the well-established rule was later limited to the course of the time, where the cases specifically revealed willful and conscious wrongdoing by the defendant, and all the exceptions regarding the rule was listed as under. So, Merry versus Nixon, the case law is applicable only in the few cases, but not in all the indemnity cases. In the indemnity cases, naturally, both of them would be held responsible. Are you following me? The rule was not applicable in cases where involved the negligence. Negligence involved is there. The rule is not applicable. Meriwether rule is not applicable. Where there was an unintentional breach of a law. Not applicable in case of the indemnity also. The rule Meriwether is not applicable. Where one man employed another to do a certain acts, provided the acts were not unlawful in themselves by way of their existence for the purpose of setting the light. Suppose for the employee's activity, who will be the responsible?
Principal.
ఎంప్లాయీస్ యాక్టివిటీ అన్నా నేను ఏజెంట్ యాక్టివిటీ అనలే. ఎంప్లాయర్ అనాలా? సార్ మీరు మాత్రం పడతారేంటి సార్ తప్పులు? అలవాటు అయిపోయింది నాయన తప్పులు పట్టడంలో. ఓకే, నాట్ అప్లికబుల్ where there exists a right of the contribution between the directors and the promoters of the company who are conjointly liable for the misrepresentation contained in the prospectus. But in certain places, no, partners are held liable. But in very few cases, when it is a personal thing is concerned, no, the company board of directors will not be held liable. The aspect is covered in the 62 of the Companies Act 1956. What is the latest act? Is it 1956? Latest Company Act. సార్ మేము ఫస్ట్ ఇయర్లో ఉన్నాం కాదు సార్, మాకేం తెలుసు సార్. ఇట్స్ ద ఓల్డ్ యాక్ట్. ఐ థింక్ 2002 is the new act. Taking into consideration admittedly action in the case of the collision that said that wherever the action is involved, damage caused by the vessel by the collision with another vessel will be borne equally by both the vessels. See, if there is a joint negligence of both the vessels, vessels means సార్ మాకు తెలుసు సార్ బోన్లు బొక్కెలు సార్. Vessels means
The front part. What? Pass on, sir.
వెసల్స్ నాయన, షిప్, పెద్ద షిప్ ని వెసల్స్ అంటారు. ఏమంటారు? ఇమేజెస్ చూపెడుతున్నాగండి. వెసల్స్, ఏ షిప్ ఆర్ ఏ లార్జ్ బోట్, వెసల్ ఇమేజెస్ చూసారా? వెసల్స్ చూసారా లేదా?
Yes, sir.
వాట్ అబౌట్ దిస్? దీన్ని బౌ అంటారు.
BOW.
ఇక్కడ కూడా ఉన్నాయి మళ్ళీ వెసల్స్, ఇక్కడ గిన్నెలు. సార్ వెసల్స్ అంటే రెండు కూడా సార్. అంటే ఎంటీ వెసల్స్ మేక్స్ మచ్ నాయిస్ అంటే ఇప్పుడు ఈ వెసల్ తీసుకోవాలనా, ఈ వెసల్ తీసుకోవాలనా?
ఇవి సార్
గిన్నెలు తీసుకోవాలి సార్.
గిన్నెలు.
గిన్నెలు తీసుకోవాలా? బికాస్ the context depends on what should be taken. When the word is the same, spelling is the same, pronunciation is the same, but meaning is different. దాన్ని ఏమనాలండి? హోమోఫోన్స్ అనాలనా, హోమోనిమ్స్ అనాలనా, పెరానిమ్స్ అనాలనా, ఫాల్స్ కాగ్నెట్స్ అనాలనా? సార్ ఇక మీరు బాగా కన్ఫ్యూజన్ చెప్తాను సార్ నాకు ఇవన్నీ.
Homophones.
Yeah, it is the Indian tradition that in the beginning or the ending of any program that we will make the play of the national anthem. Now the national anthem will be.
Jana Gana Mana Adhinayaka Jaya He Bharat Bhagya Vidhata Punjab Sindhu Gujarat Maratha Dravida Utkala Vanga Vindhya Himachala Yamuna Ganga
से अच्छा हिंदुस्तान हमारा। जय हिंद।
जय हिंद।